Hear ye, hear ye. The Court of Appeals for the First District of Texas is now in session. Pursuant to adjournment, God save the Constitution, this honorable court.
So good afternoon. We're here today to for oral argument. I would like the parties to make their announcements.
Your Honor, this is Mark Trachtenberg on behalf of the appellants, the Freeport LPs.
Okay.
Your Honor, you have Chad.
Chad
Yes.
Flores.
Yes, you have Chad Flores for the appellant, appellees, and cross appellants.
Okay. Well, are you Chad Flores?
Yes, ma'am.
Okay. Your picture is so small, it's hard to see who you are. That's why I asked.
Okay.
Okay. Before we get started, what I'd like to do is throw my questions out so they don't take up the time before the time clock goes. So I know you're going to have your own points you want to discuss, but I'd like for you, on behalf of the court, to be sure and touch on these points. And one of them, is there any law on how you can get attorney's fees when you win some and you lose some? And the jury found that a party breached its fiduciary duties. I want to know if there's any law on that. And the other question is about reimbursement. How do you get reimbursed when the case was not, was it sought? It wasn't pled. It wasn't tried by consent, and there was no jury question. So those are my two questions. So Mr. Trachtenberg, would you like to begin?
Yes, Your Honor. May it please the court. Mr. Royal does not challenge the jury's determination that he breached his fiduciary duties to my clients by pilfering 7 of the 9 disputed tracts in the marina development. And this appeal is about whether my clients, the Freeport Limited Partners, should be made fully whole for the full scale of his misconduct as their general partner, including his theft of the 2 other tracts at the heart of the marina. I was going to focus on 3 topics in my presentation. First, that Royal breached his fiduciary duties in connection with his acquisition of the Stanley tract. Second, that he breached his fiduciary duties in connection with the Henderson tract. And third, that the limited partners are entitled to an award of attorney's fees under the partnership agreement. So I'm going to jump to the third point, and I'm glad of your question, Justice Raddick. I think the reimbursement question you just asked really is directed to Mr. Flores. We agree with you that there was no pleading, no proof put on the $100,000 award that was made to them. And so I will address whatever Mr. Flores says in rebuttal to that. But I think your question raises precisely our point on that issue. With respect
Well, the problem is that there's no opportunity for you to defend against it either.
That's exactly right, Your Honor. This all came out in letter brief submissions after the trial, well after the trial. The attorney's fees issue is an interesting question, Your Honor. I mean, we think if you reverse on Stanley and Henderson, this court's decision is fairly an easy call as to who the prevailing party is. But if the judgment remains, even if the judgment remains unchanged, the limited partners should still be deemed the prevailing parties for the purposes of the mandatory fee award. This court held in the Drummond case that the prevailing party is the one who prevails on the main issue and is vindicated by a trial court's judgment by obtaining some relief, whether equitable or monetary, even if that relief is not as extensive as was originally sought. And as your court's question, as your question implies, Your Honor, there are always lawsuits involving multiple claims and counterclaims. And so this court explained in Drummond that in a jury trial, we should look at how the issues are presented to the jury to determine the main issues. And there are some, and here the main issue, the vast majority of the parties' arguments, the witnesses' testimony, the jury submissions, all related to the fiduciary duty claims that we brought.
Well, so was the city tract, district tract, whatever you want to call it, was that the prize piece of property?
Your Honor, yes. I mean, it was 7 of 9 of the 9 disputed tracts, and 70% of the disputed acreage goes to city and district. But let me explain Mr. Royal's argument. He has a 2-step argument for why he should be, even though he's an admitted bad faith breacher of fiduciary duties, why he should be deemed the prevailing party instead. He points to a couple cases where courts have found that there can be multiple main issues in cases, and that we should count our fiduciary duty claim as 3 separate main issues. And then he claims to have prevailed on 3 of the 4. But our view is this is wrong. I think every complex case has multiple claims and counterclaims. And these fee shifting provisions would be meaningless if the court can determine there were main issues pointing in both directions. We think that that type of case really is reserved for very rare circumstances, as in the Mohican case, where they said there really were two issues of equal importance as they were laid out in the trial. But we think, except in those rare circumstances, the trial court has the obligation to sort through those issues and pick the main one based on how the case is presented and the interests that are at stake. In addition, we would point you to the flagship hotel case that's cited in our brief, which teaches us that it's improper to break down the fiduciary duty claim into three separate main issues, as Mr. Royal proposes. In that case, the hotel was deemed the prevailing party in its dispute with the city of Galveston, even though it prevailed on only one of the three contractual breach theories, and its recovery was much smaller than was hoped. The bar is not high under the Supreme Court's KB Holmes case. We simply have to get some equitable or monetary relief. And we think that that's the case here, where our overall trial theme was that we were cheated by my clients were cheated by their self-dealing cousin, and they were vindicated by the jury's fiduciary duty findings and the trial court's award of equitable relief. So for those reasons, we believe we should be deemed the prevailing party, even if the judgment remains unchanged. But for the first 2 points I was going to make, we don't think the judgment should remain unchanged. We think we're entitled to an award of a constructive trust for the Stanley Tract and the Henderson Tract as well. With respect to the Stanley Tract, at tab B of our oral argument exhibits, I've summarized the key facts of that transaction through which Royal took this property from the partnership. The partnership originally owned an exclusive option to purchase.
Can I just interrupt you for just a moment?
Your Honor, sure.
So are you basically saying that there's no legal or factually sufficient evidence to support the jury's decision with respect to those two tracts?
I'm saying that that's correct. So the way this should be framed is Royal has to run the table on all of the elements of fiduciary duty that are contained in jury questions 14 and 19, which are behind tab D of our exhibits. Because those elements are listed in the conjunctive, and because Royal had the burden to overcome the presumption of unfairness with these indisputably related party transactions.
May I ask you a question about those elements? If we take as true all of the testimony about the alleged August 2006 phone call, can you walk me through your position on why those elements wouldn't be satisfied, even if we took all of that as true?
Yes, Your Honor, several points there. So the phone call itself, even if you take it as true, whether there's been a full disclosure is just one out of the 5 elements in question 19. And that's also drawn from the case law. It's only one of 5 factors that this court looks at. If you look at the Lee versus Hassan case, which is out of the 14th, but same test in the first court, it's only one of 5 factors for ascertaining the fairness of a transaction when there's a related party transaction with a fiduciary. And there's plenty of cases, including the Mesquite case that we cite, as well as the Sorrells case, where courts have held that even where there's full disclosure, they still overturn jury findings of fiduciary duty compliance and find a breach because the overall nature of the transaction was so unfair. And that's the case here, Your Honor. I think one other point about the August 2006 phone call, part of the test is not just whether he calls and says, I'm going to obtain this property. It's whether he discloses the nature and effect of the transaction, the importance of the transaction. And there's no testimony in the record about what he said to his cousins to obtain this consent. There's no evidence that he made any kind of disclosures, for example, that he was in the process of negotiating with the city of Freeport to obtain a ground lease where he would get 40 years of rent, for the Stanley Tract, which was virtually happening simultaneously as when he's executing this transaction to obtain this tract for no consideration. So it's a several-fold answer there, but simply taking that testimony on its face should not change this court's analysis on the breach question. I would point out there's also a separate good faith and scrupulous honesty element in question 19, and there's no evidence that Royal met that element. So, for example, he imposed a false unanimity requirement for the purchase, even though a sufficient majority of the limited partners indicated that they wanted to participate. And then he said he didn't want to set up a separate entity to purchase the property. And then, of course, a week before he acquires it, he sets up his own separate entity. And then in Defense Exhibit 87, which I think is really telling, he lied to his cousin in 2014 about not remembering what happened to the option. He was asked point blank, what happened to the Stanley option that the partnership had? And Royal said, I don't remember.
Yeah,
even though
but isn't that many months later?
that is months later, but they were, the evidence was they were not, they didn't find out, according to the jury. They couldn't have found out about Royal's breaches until, I think November 19th, 2014 was the jury's answer. So they were.
To get to the second of the Chief Justice's questions about equitable reimbursement before you run out of time.
Yes.
Or you can save it for your rebuttal.
Either way.
Well, I'm happy to address it. So we have three arguments there. I think the easiest one for the court is, can an admitted breacher of fiduciary duties who has not contested the fiduciary duty violations as to city and district, does he have unclean hands, and can he obtain what's an equitable reimbursement with unclean hands? We think the answer is clear. We don't think that case law that we've cited at our briefing has been distinguished at all. So I think that's an easy answer. And I think given the unchallenged fiduciary duty findings there, I think the case law that we've cited is clear that the unclean hands finding is almost automatic. There's also the pleading and proof issue. As we pointed out, that all came up after argument. There was no pleading requesting equitable reimbursement at all in the case. And finally, just in terms of the math, his offset number, the $100,000 was just drawn out of thin air. And if you take into account any revenues attributable to the city and district tracts, you would get to zero very quickly. And I think another really quite amazing point is that Royal counts his cost of capital in that calculation when he's setting forth his number for what his costs are. He's saying I should get the cost back for the investment I made to basically steal your property, and I should get what I would have made in the market had I not stolen your property. So
I know we're almost out of time, but just before I forget, can you touch on the question of the dissolution of the partnership, if possible?
Yes.
Quickly?
Yeah, Your Honor, that's absolutely, and that's why I think the evidence is conclusive here that we met the elements of quasi estoppel and equitable estoppel. We urge the court to look at DX9, DX12, and DX13, where Mr. Royal is clearly saying that he is agreeing to allow a majority to replace him, not just remove him. They claim in their brief that it was a slip of could have been a slip of the tongue, but when it's 3 times in writing, including one communication to a bank trustee, we just don't think that's plausible. We think that quasi estoppel should defeat the dissolution here.
Okay, let's hear from Mr. Flores.
Thank you, Your Honor. Thank you, Your Honor. May it please the court. The court has before it an appeal with a litany of issues where
Okay, so we have the same questions that we had before, just so you know.
Sure, I think I can.
Questions to you.
Great, thank you, Your Honor. I'll integrate those very soon. If the court will permit me a slight introduction, we have before us an appeal with a litany of issues where the limited partners say that they lost a jury finding that matters, that they lost another jury finding that matters, that they lost multiple court rulings that really matter. That's all on their side of the appeal, that they lost in a litany of ways and they care deeply about it. And then in the cross appeal, the gist of their position on attorney's fees is that they didn't lose, but that they won by getting $1. These two positions are totally inconsistent. In fact, the jury verdict and the trial court ruling should be affirmed. That's why our side won the case. And that's precisely why we should get fees. And let me jump straight to the court's questions about attorney's fees and this notion of obtaining fees on a partial win, if you will. The question is, do we get fees if we only won on what we say are 3 out of the 4 issues? I don't think the court has to reach that question for 3 reasons. Number 1, of course, is that we submit that we didn't win just 3 out of the 4 main issues, we won all 4. So when I say the 4 issues, I mean issue number 1 is the declaratory judgment that we sought. and then the main issues as to each 3 tracts of land. So that's one reason.
Mr. Flores, you were found liable for breach of fiduciary duty.
So, Your Honor, we quibble slightly with that, but I don't want to fight it too hard. Remember that the findings were for our side to prove compliance. And so we successfully proved compliance as to Stanley. We successfully proved compliance as to Henderson. And we just have a failure to find as to the city and district tracts. My friend on the other side likes to say that they had a finding of bad faith, but there is no finding of bad faith. We just didn't carry our burden. I understand that doesn't get me all the way there, but it's an important distinction to draw. And the other answer I have is that our right to attorney's fees is not an equitable right. It's a legal right vested by the contract. And so the contract makes these adjustments as a matter of law. And indeed, the entire point of the main issue doctrine, the part of it that says you can have multiple main issues in a case, is because sometimes there can be wrongdoers on both sides. And so what you'll see in the decisions that interpret contracts just like that, this is the Mohican decision and the BSG decision, is those decisions are interpreting the contract. And what they say is it's a matter of contract interpretation. What these parties meant was to recognize that cases can have multiple issues, and then you have to look at each of the multiple issues here. And so if the court disagrees, they don't think that we won all 4. I do think we won all 4, but if we only win 3 out of 4.
But the outcome is that you had to transfer those city and district tracts back to the other side. Is that not correct?
That is correct, Your Honor. But remember, the question isn't, did some pain get inflicted on my side of the case? The question is, did the plaintiffs actually prevail and win? And they were looking for 2 things, and they got neither. Number
Wasn't
one,
the value of the city and district tracts, most of the value that we were discussing in this case, or is that
no,
not
Your Honor, not at all. Remember, the first and foremost relief they wanted was actual damages and $4.3 million plus punitive damages, and they got $1. The other thing they wanted was control of the entire marina, and they didn't get that. The reason they didn't get that is because they needed all 3 legs of the stool. They need to both win as to Stanley and as to Henderson and as to city and district. All they got was one finding, a favorable finding on city and district, and even that doesn't get them the property. Because remember, because we won the issues of dissolution, all that happens is that they pay us for the property, and then it has to get sold in liquidation. So their real 2 goals here are to get paid a lot of money in actual and punitive damages, which they got $1, or to get control of the marina, which they don't get either. They're trying to reframe the case after the fact. But as I say before, look at the initial side of the appeal. The reason they have a litany of issues on the front side of the appeal is because they lost what they actually want to win.
But Mr. Flores, they are the ones that withdrew the request for the 4.3. I'm not quite sure I understand how that worked or why that was, but I will let Mr. Trachtenberg respond to that. But isn't that true?
That is true, Your Honor, but that's a point in our favor and not theirs. Remember,
Okay, well, I don't really understand why they did that.
I can tell you why we think they did it. I think they did it because they were going to lose. There's no way they were going to get those damages. When the court evaluates what the litigation is about, you don't look to just the things that made it all the way true. The precedents say you look at what was pleaded, what was litigated before trial, what went to trial, even what happened on appeal. And so the whole point is to say, if they want to get paid, you ask, what did they fight for? And they fought for years and years to get those damages, and we won that fight. So much so that it was out of the case by the time of trial. But that doesn't change the nature of the issues in the case.
Well, you didn't totally win because the partnership's being dissolved, and the money that arises from the value of the partnership is now going to be divided among the limited partners.
The partnership is dissolved, but that was our request for a relief. That's a point in our favor, not theirs. Our declaratory judgment action says that because of the mutiny that they tried to accomplish, because that was invalid, the result must be to dissolve the partnership. And that's important for us both in principle to vindicate our legal rights and practically. By winning that declaratory judgment act claim, we took the legs out from all of their, what are in effect, counterclaims. Because the partnership gets dissolved, everybody has to walk away. And now they have to walk away with $1 in damages. So at the end of the day, you say, if there's one winner in this case, it's definitely our side. It's certainly not theirs. And if you divide up into 4 issues, we also ran the table. Let me say one thing about procedural posture here. Remember that the argument you have from the other side about attorney's fees goes all in on their theory that there can be only one main issue in the case and that they won it. So when you resolve their part of the appeal, you say, is there only one issue in the case? And is it the one issue that they have identified? It's not. There were multiple issues, and it certainly wasn't that issue. You're done. That's their only argument. They don't even try to argue that under a multiple issue theory, they should somehow get fees. But the easy answer I can give the court is that how to resolve this issue is to do exactly what happened in Mohican. Reach the point where you say there are multiple issues in this case, multiple main issues, and then remand. Let the trial court determine in the first instance exactly what the issue divisions are, what the fee amounts are, and if there's some sort of mixture or commingling, we get 3, they get 1, we can litigate that for the first instance below. But that wasn't litigated below at all here, and that's part of the original error.
Are you saying is a winner take all though? When on the remand, you know, there'll be part winning on part damages for one and part damages for Stanley and Henderson? Is that what you just said? I'm sorry, I didn't follow you.
So in theory, in general.
On remand.
Yeah, so on remand, that could be possible generally. We think that we're going to run the table and win 4 out of 4 and get fees as to 4 out of 4, but it is theoretically possible for a court to say party X to the contract prevailed on 3 main issues and is a prevailing party, and the other side is also a prevailing party as to 1, and then you would have to figure out how things weigh in the balance. I don't know exactly.
We under the contract have to decide who is the winner in order to assess attorney's fees?
I don't think that's the case, Your Honor. We haven't litigated it here, and so I don't want to ask the court for a decision because we haven't given them full briefs on it about how that would play out. But I don't take that to be my friend's position on the other side. The only argument before you is there just one issue or are there multiple? If you think there are multiple, you reverse and remand, and then we go after the multiple, however that permutation may spin out. The reimbursement issue was posed by the court, and I want to address that because we have several levels of response. One of the arguments we get from the other side is that we weren't entitled to reimbursement because it wasn't pleaded, and that's wrong for 3 reasons. The first reason it's wrong is that this pleading argument wasn't made below. If we somehow foisted this on them in the trial court, they needed to say so, and the reason they needed to say so below so that we could have sought a trial amendment or cured below. But if they're going to
wasn't this raised for the first time?
How could they do that when the reimbursement arose after the fact? There was no expectation for a reimbursement.
So, Your Honor, we challenged that
reimbursement. I'm sorry. I thought you had not pled for reimbursement.
I'm sorry. Could you say it again, Your Honor?
I didn't think you had pled for reimbursement, had you?
Correct. We didn't plead for reimbursement, but let me be very clear. The reimbursement issue was in the case necessarily because of their request that this contract be canceled and rescinded. That is necessarily implied, and this isn't just me making this up. This is the Supreme Court's decision in the Johnson case, right? Johnson versus Cherry. Remember, the request of reimbursement happened for the first time in the Court of Appeals, and the Supreme Court held that is totally fine because it's necessarily implied by what the other side is asking for. That's exactly the case here. Necessarily implied in their request to undo this transaction is the notion that there's going to be reimbursement. And so that's
why isn't that a question for the jury as to the amount of reimbursement due, and why wouldn't that be your burden to procure a finding on that?
We could either try it to the jury or to the court, and we don't care either way. We're happy to have that issue tried to the court in this case. And
did you have the chance to plead it, to try it to the jury in the trial you just had?
I'm sorry?
Didn't you have the opportunity to plead it and try it?
The issue was in the case, and we tried it to the court. That's how it always works in any case. If people don't demand a jury trial on some subset of their claim, then the issues are necessarily tried to the court. That's what we did, and we got the findings on the amount, and that's why we have the judgment that we have. And so we're perfectly confident in the amount calculation, to be sure, but on the procedural question of whether it was pleaded and whether they had an opportunity to present evidence, it's clear that it was tried. This is why you have tons of evidence about the offsets, right? My friend on the other side just made the argument that they proved that the offsets were going to counterbalance what we paid to make this property happen. That proof exists precisely because everybody knew that this was at issue. And so
he said you got this out of thin air. So you want to respond to that?
The amount that we got out of the, no, Your Honor, it's just wrong. So we briefed this already. You can see it in our brief at pages 55 and 56. Remember, in these types of cases where you prove reimbursement, first you have our expenses, and we have proof of expenses, not just in the $100,000 amount, but in fact exceeding $230,000. And then on the other side of the ledger, you can see in our brief on pages 55 and 56 that we go through their proof of what the offsets should be. And the problem with the offset proof is that they don't have a reasonable way to distinguish which of the properties are responsible for how much of the profit. My friend on the other side told you that the city and district tracts were the keystone property and that they drove all of the value, but that's attorney ipsa dixit. The proof doesn't actually show that. The other side needed to divide this up. And the reason they didn't divide it up is because they were going to shoot the moon to get all three properties, because they had to get all three properties. They had to win as to all three in order to take control of the marina. And by failing to win all three, they effectively lost the case. And so that's what our view of the case makes harmony of all these dynamics, but theirs really throws it into chaos.
Can I ask you to touch on the partnership dissolution question before you run out of time, please?
Yes, Your Honor. The partnership dissolution is the issue that we cared deeply about from the very beginning. We didn't need to introduce jury questions on that because everything was proven as a matter of law. This is not a long partnership agreement. You only have to look at two provisions of the partnership agreement to see why dissolution was required. Number one is section 12.2. We've excerpted this in the briefs already, and it says unequivocally that if the general partner gets removed, the partnership has to be dissolved unless everyone unanimously picks a new general partner. There was not a unanimous selection of a new general partner, and so by virtue of the clear text of 12.2, the partnership has to be dissolved. Now, the limited partners then tried to get around that with more amendments and try to change the partnership agreement, but those amendments also didn't comply with the partnership agreement. You'll see that in Article 17. That's the second piece of the partnership agreement that's critical. And that says that if amendments are going to happen, amendments have to be executed by the general partner, but there was no general partner. Now, I am confident that when the court looks at this limited partnership agreement, there's nothing absurd about this. There's nothing unreasonable about it. The notion is that if someone wants to, in effect, have a mutiny, right, there needs to be an orderly and agreed upon succession. And if there isn't an orderly agreed upon succession about a general partner leaving and a new agreed upon general partner coming in, these parties saw in advance the partnership won't continue and it shouldn't continue. This case proves the point. Sort of mutiny that occurred shows why the partnership can't go on and it shouldn't go on. And that's thrown out by section 12.2 and by Article 17. So that's our answer on the dissolution question. Unless the court has any further questions, we'll be happy to submit them in the briefs.
I do have one last follow-up just on the Stanley Tract issue. You can see that Royal has to prove that he acted in the utmost good faith and exercised the most scrupulous honesty toward the limited partners as part of his burden of proof, right?
Yes, with an asterisk. The asterisk I'll give you is the Swenson decision. We tell the court that the Swenson decision from the Supreme Court in 1974 tells you that when the plaintiffs consent, all you really care about is whether it was disclosed in full. And on the reply brief on page 8, my friends on the other side say Swenson is good law, and that's the rule. So it's a rule of thumb, you could say, that in cases like this where there's consent, which there was, we just need to have shown them what was happening, and we think that necessarily solves the factor by factor mother hugger charge.
But does the consent still apply when it does look like even under exhibits 48 and 49, there are true misrepresentations here about a need for unanimity and not being prepared to create another entity to go through with the $90,000 transaction when it happens, I believe, the very next week. Do those negate consent if there are misrepresentations? How does that play out?
So I think Swenson accounts for that, Your Honor, because it's a question of were they informed and did we give them the information they needed? There's a distinction between sort of a tricky deal and a bad deal. If anything, these people maybe signed up for a bad deal because of the prices, but it wasn't a tricky deal because everything was disclosed and everything was informed in the beginning. So that's the best our position is. Thank you, Your Honor.
Thank you. Mr. Trachtenberg.
Yes.
I guess the most surprising comment I heard was that he didn't really find breach of fiduciary duty.
Your Honor, I can read the jury charge as well as me. The court certainly, the judge, the jury and trial judge certainly found a breach of fiduciary duty with respect to the most valuable tracts in the marina, and awarded very significant equitable relief. And the KB Holmes case from the Texas Supreme Court makes it clear that the bar is not high for a plaintiff to be deemed a prevailing party. You just have to obtain some monetary or equitable relief. And we certainly believe that those findings, in combination with the finding that the jury was asked whether he acted in good faith in connection with that transaction and answered no, we think that certainly should get us there in terms of prevailing party. I think the other flaw in the analysis is there's not a single case I found in where any court has found more than two main issues, and we think those two cases are pretty unique in that courts were careful to say they were of equal importance. The vast majority of cases, including the Drummond case, you always have claims and counterclaims going forward, and none of these courts say, well, we're going to treat all these as main issues and just kind of tally it up. That would really defeat the purpose of the contractual fee shifting provision. And we believe, again, the case law is clear that you don't have to prevail to the extent you originally sought. You don't have to get the full amount of damages you requested. It's not a high bar, and we believe that our framing of this analysis is correct. I want to jump real quickly to the last point that my friend on the other side made about the Swenson case. That is a case where that involved just a bequest from some women to a museum in their county. There was the reason adequacy of consideration wasn't an issue there because it was a gift in that case. But there's no case in Texas that says if you provide a full disclosure, that's it. You're free and clear of any fiduciary duty violations. The courts are over and over in the cases we cite, Sorrell, Mesquite, all Lee versus Hassan, all emphasize that you look to the entire fairness of the transaction, and disclosure is just a part. And the disclosure and the charge itself sets out the elements and says that Royal has to meet each and every one of those elements to be able to say that he complied with his fiduciary duties. Just a few points on the kind of rescission reimbursement issue. We didn't ask for cancellation. There's not a contract that we're asking for cancellation. This is not the case law he's talking about are rescission cases. The remedy we're talking about here is a constructive trust remedy. And so we didn't try it by consent. We didn't try his amount by consent. The evidence, he says that because there's no pleadings that put us on notice. And the evidence that he's claiming was evidence was just letters, documents, unauthenticated documents attached to letters after trial. We don't think that is sufficient. And just to be clear, Your Honor, I wasn't saying they took their numbers out of thin air. I was saying the judge's amount, $100,000. That number was nowhere in the record. So there's really no way to really track the court's reasoning on that. And finally, with respect to dissolution, the timing is really incredible. When you look at PX1 and you look at Royal's signature block on the partnership agreement, he signed it on April 8th, 2002, or April 9th, 2002. Literally the same day, the day before he signs the side letter agreement, April 8th, saying that the majority of partners are going to have control over this partnership, and majority interest can replace. The same day he signs the partnership agreement, he sends a letter to a bank trustee to try to induce Mr. Blaffer's siblings into the partnership, and says, I can be replaced at any time by the will of the simple majority of the limited partnership interests. And he's saying this multiple times. We believe at a minimum, the elements of equitable estoppel, this is a perfect case for this. It's quite amazing that that counsel is coming in here saying, even though I stole these properties and I breached my fiduciary duties, I'm still going to be the winner because the forced sale is going to not culminate in any real reward to the limited partners. That just kind of puts a bow on it. I see I'm out of time, Your Honors, but I appreciate your consideration of this case and thank you for the opportunity to argue before you.
Okay, Judge Goodman or Judge Ferris, do you have any questions?
No.
No, Your Honor.
Okay, thank you both very much.
Thank you.
Court